Good afternoon. My name is James Velma. I'm a partner with Lathrop GPM here in Boston, working a biotech patent attorney, working in a variety of technologies, including CRISPR and other nucleic acid technologies. I'd like to speak with you today, bring you up to speed a little bit on what's going on with the CRISPR battles globally. You're well aware of the interferences with Broad and Berkeley, and we'll talk about that, as well as some other more recent ones. So just as a reminder, what we're talking about here are the fundamental patents regarding the use of CRISPR for gene editing, use of Cas9 either to knock out a particular gene or make edits in a particular gene with the generation of insertions and deletions by non-homologous end joining, or alternatively making a double standard break and introducing a heterologous donor fragment that would be knocked in by homologous directed repair. So these patents concern this basic process. The difference is, in what system are they being used? Since these fundamental patent filings, the CRISPR patent landscape has exploded. We've seen an exponential growth in patent filings. This is from 2018. And probably an order of magnitude or more filings since 2018, and this of course tracks the explosion of research that's being used, that's employing CRISPR in a variety of ways, either as tools, as diagnostics, or as therapeutics, and so on. But as for the fundamental patents, which pose potential freedom to operate issues for certain parties. The fundamental patents between Broad and Berkeley concern in what systems CRISPR would be employed. So the Berkeley filed a very broad patent filing directed to CRISPR in any system, in any environment. Whereas a few months later, Broad filed specifically the use of CRISPR in a eukaryotic environment, which of course is particularly relevant for human therapeutics. So way back in 2017 now, the PTAB made a decision following an interference, deciding whether or not these two inventions, an all-system type invention of Berkeley or the eukaryotic specific invention, were in fact two separate inventions that are patentable over each other. And the PTAB made the finding that in fact there was, these were distinct and patently distinct inventions. That the eukaryotic, the use of CRISPR in a eukaryotic system was patently distinct over the all systems generic invention. And in making that decision, they really relied on the evidence built up that there was no reasonable expectation of success to use the system in the CRISPR approach in the eukaryotic system. And so it was a non-obvious and patently distinct sub-invention encompassed by the all systems invention. So this decision was appealed to the CAFC, our federal appeals court, which sided with the Patent Office, the Patent Trial and Appeal Board, and affirmed that decision since it was heavily evidence-based. They found no reason to disturb those findings, and indeed the Supreme Court also declined to take that up. So having found that these were in fact two separate inventions, a second interference was declared to determine who was first to actually invent those inventions. In particular, the count that's focused on the subject matter of the invention is CRISPR in eukaryotic cells with single guide RNA. In interferences, there's a motions phase and a priority phase. In this motion phase, the PTAB decides who is entitled to the respective priority dates, who gets the earliest priority date, before then deciding who was first to conceive. And the board found that the Broad was entitled to the earliest priority date of December 12th, 2012, whereas Berkeley was only entitled to a later priority date of January 28th, 2013. And so now we move to the priority phase, where Berkeley now has, as a junior party, has the burden of showing that they had prior conception of the invention in eukaryotic cells, and we hope to see a decision on that in the coming year or so. Should say that all of this interference proceedings is a result of the fact that these inventions were made in the waning months of the old law. In December 2012, in March of 2013, our law changed so that it's not a first to invent system, but a first inventor to file system, as we'll see in Europe. So had these inventions been filed only a matter of months later, after March 2013, we would not be in this situation with this complicated interference scenario. I'm going to turn it over to my colleague Mike, who will discuss some of the more recent interferences with lesser known parties that make this situation even more complicated.
Yeah, so as James mentioned, the Broad and Berkeley proceedings have certainly received the most publicity, but other parties were working on CRISPR genome editing in eukaryotic cells at the same time in 2012. One such group, Tool Genes, a Korean genome editing company, also filed priority patent applications in early 2012. And they have patent claims that are also directed to the broad concept of genome editing in eukaryotic cells. And so as a result of those claims being presented, in view of the claims that have issued to Broad and Berkeley separately, two interferences have been declared for the same purpose as the interference between Broad and Berkeley originally, to see who had priority to this concept of eukaryotic editing. So one interference is between Broad and Toolgene. The second one is between Berkeley and Toolgene. Again, centering on the same issues, who is the first to reduce eukaryotic editing to practice. And so we'll see, again, this is early stage, only recently filed in December of last year. So we haven't gone through the motion phase that James had just mentioned. But once that has been established, we'll have a better idea of who had priority to this concept first. Similarly, another group, Sigma Aldrich, was working in this space at the same time. Although there is no interference between Sigma and Broad or Berkeley, but not for lack of trying. Sigma does have allowed patent applications to the concept of integrating a heterologous sequence into the genome using CRISPR editing, a knock-in approach. Unfortunately for Sigma, those claims are limited to very specific nuclear localization signals on the Cas9 protein. although Sigma is pursuing other claims to try and cover eukaryotic editing in general, as well as knock-in approaches without the requirement of any particular nuclear localization signal. Sigma has petitioned the US Patent Office to declare an interference in much the same way that Broad and Berkeley have dealt with it, and Broad, Berkeley, and Toolgene are now dealing with it. But because Sigma has yet to obtain those broader claims or shown any indication that they could obtain those claims, the Patent Office has decided not to declare that interference. So as of yet, Sigma is sort of on the outside looking in, but nonetheless, they have been able to obtain some claims on this broader concept. Just to give you an idea of how complex this issue is, as James was talking about, this all happens because these filings occurred before the change in the law. So it all centers on who was the first to invent this concept, regardless of when they filed their application. Berkeley had filed their applications before anyone else, but did they reduce to practice the concept of eukaryotic editing? Toolgene filed their applications a few days after Berkeley's second application, Sigma a couple months after that, and Broad, their first application was actually the last filed application, only 6 days after Sigma's. But at least for now, Broad seems to have been able to establish that they had shown eukaryotic editing prior to anyone else, based on lab notebooks and other notes from Feng Zhang, the inventor. So that is, it's kind of has a snapshot of why it can be complicated trying to figure out who came up with the concept first when you have so many filings in such close proximity to one another. Some of you may have heard about the issues in Europe being a little bit different. The Broad Institute has enjoyed some success in the US, but that has not been the case in Europe. In fact, several of the core CRISPR patents for the Broad Institute have been revoked in Europe. This largely centers around the fact that the Broad Institute failed to include co-applicant Rockefeller University and their scientists as applicants on the application, even though they were collaborating together. And because they didn't have a one-to-one relationship between their priority documents and their final application, they lost their priority claim. And because they didn't have that priority filing date in this first-to-file system of Europe, they lost novelty as a result of prior art that came about during that intervening period. And this is just a odd nature of the European practice, and ultimately this decision was upheld, and it can't be cured as it could have been in the US. So these broad patents have been revoked. Berkeley has not been immune to this, however. Berkeley does have a European patent that was revoked on chimeric Cas9 concepts, where it's a fusion to some other enzyme, such as for base editing, for example. This patent was revoked recently because Berkeley hadn't shown this concept in their earliest priority document of May 25, 2012. So it was also found invalid for lack of novelty in view of some other publications that came after this date. But this is only an issue so far with these chimeric Cas9 concepts. The other core Berkeley patents that cover Cas9 editing in general have gone through an opposition proceeding, but they've actually come out intact. They've been maintained. So Berkeley still has these broader patent claims in Europe, although that decision is being appealed as well. So it'll take a few more years before Berkeley's fate is decided, at least in Europe. So there are a number of parties, a number of contentious proceedings ongoing, not just Broad and Berkeley, but Toolgene, Sigma, all having filing dates around the same time, all working to try and establish this concept of editing in eukaryotic cells. And it's going to be another few years before it can all be sorted out. So with that, we thank you for listening, and we're happy to take any questions that you might have.